This is an image that breaks down the difference between civil rights versus civil liberties. This is very important as we continue through this chapter. Civil rights are government guarantees of political equality. Think as far as groups of people. Civil liberties, however, protect individuals from government interference. Civil rights do tend to apply to groups, whereas civil liberties apply to individuals. Civil liberties are guaranteed in the U.S. Constitution and in the Bill of Rights. Civil liberties address concerns such as speech, the practice of one's religion, and the use and ownership of property. Americans usually believe that the government should not interfere with these areas unless there are fundamental and compelling reasons to do so. Nationalization of the Bill of Rights protected individuals against actions of state governments. However, this does not require uniformity among the states at the state level. States are free to interpret some civil liberties as they choose and apply them at the state level in different ways. So long as they abide by national guidelines, states can take liberty to apply certain civil liberties in different ways. Civil liberties are another name for individual rights. Civil liberties are chiefly concerned with liberty, whereas civil rights focus on equality. Americans expect government to protect civil liberties such as freedom of speech and press, religion, and assembly, and we also expect government not to interfere in the exercise of these liberties. American political culture maintains that these rights are not granted to us by government, but they are inherent to us as a people. The House of Representatives starts each day with a prayer delivered by religious figures from different faiths. Is this an unconstitutional violation of the separation between church and state, or an acknowledgement of the importance of freedom of religious practice in America? The Bill of Rights protects civil liberties, but the structural principles of the Constitution, such as separation of powers, checks and balances, federalism, and limited government, also protect them. Also, the Constitution declares that only courts and juries, not the legislature, can determine whether an individual is guilty of a crime. Bills of attainder are also prohibited. Habeas corpus cannot be suspended except during wartime, and no person can be tried ex post facto, which means before the crime has been committed. The Federalists believed that a Bill of Rights was unnecessary. They felt that the Constitution contained specific guarantees of liberty. The structure of government was designed to protect the rights of citizens against tyranny. But because people feared a strong government, the Federalists added a Bill of Rights so that the Constitution could be ratified. The provisions in the first 8 amendments provide protection against the actions of all 3 branches of government. The 9th Amendment states that the failure to list rights in the preceding amendments should not be presumed to mean that the people do not have those additional rights. The 10th Amendment declares that powers not given to the federal government are reserved for the states or for the people. There are 3 categories of rights protected in the Bill of Rights. We will discuss all of them in this chapter. Throughout the 19th century, the Bill of Rights only applied to the federal government. For example, the federal government could not violate the First Amendment by establishing a national church, but a state could. Beginning in 1897, the Supreme Court began to apply the Bill of Rights to the states using the due process and equal protection clauses of the 14th Amendment. This is called selective incorporation. For example, it ruled that freedom of speech is a fundamental right and is incorporated under the 14th Amendment's protection of liberty. The Supreme Court did not simply declare that the entire Bill of Rights applied to the states. Rather, over time, in different cases, the court ruled that different parts of the Bill of Rights also applied to state governments, and the Second Amendment was not incorporated until 2010. The Fifth Amendment protects people against self-incrimination. In 1966, the Supreme Court considered this as the right to remain silent and protected people accused in state and local proceedings under the Due Process Clause of the 14th Amendment. Ernesto Miranda, shown in this photo, was arrested and not informed of this right. His conviction was overturned after the court required police to deliver the now famous Miranda rights when an individual is arrested. Which amendments have not yet been incorporated? This is a chart, an image that will show you the incorporation of very specific amendments. Pause the video if you want to read through the list. Nationalization of civil liberties means that most of the Bill of Rights guarantees now also apply to state governments. But in some areas, the Supreme Court has allowed flexibility in how states apply these protections. For some rights, such as freedom of religion, there is little variation allowed. A state would need to show that it had a compelling reason that to limit the right known as the strict scrutiny approach and that it had pursued this limitation by the narrowest means possible. The court allows more flexibility in so-called non-fundamental rights, such as just compensation. States must protect these rights, but specific legislation can vary from state to state, such as limits on medical malpractice compensation. Over time, the Supreme Court has adopted a series of standards that have expanded the right of free speech. Even in difficult cases when the speech might lead to illegal acts, the court's interpretation of particular categories of speech, such as obscenity, have also shifted over time. First Amendment freedoms, including freedom of speech, hold a preferred position among American civil liberties. We are going to look at some specific standards that the government has used to interpret freedom of speech. The government can limit free speech by a method called prior restraint. It simply forbids some speech. As a kind of censorship, the government seldom wins these cases. For example, when the government tried to forbid the publication of the Pentagon Papers based on State Department documents, the court ruled the public had a right to know. The government may also limit speech by declaring that speech that has been uttered is a crime. This restriction is placed on hate speech. The court has ruled that hate speech cannot be considered a crime. For example, when the Westboro Baptist Church taunted families during funerals of gay soldiers, the court reluctantly declared that, as distressing as the speech of the church members was, it is nevertheless protected by the First Amendment. In a 2002 decision, the Supreme Court declared that cross burning, even though hateful, was constitutionally protected as symbolic free speech, as long as it was not designed to be intimidating and make particular targets fear for their safety. If intimidating and making people fear for their safety were the intent, the cross burning would not be constitutionally protected as free speech. Should the same symbol be treated two different ways legally? Over time, the Supreme Court has generally expanded the scope of free speech, but speech that has supported criminal action has tested the limits of speech rights. Until 1919, the Supreme Court was guided by the bad tendency standard. If certain acts were criminal, then speech that deemed to advocate such conduct, speech that had a bad tendency, was itself criminal. The burden fell on the individual to demonstrate that the government's speech restriction was in some way unreasonable or that the speech in question was not actually supportive of illegal conduct. Convictions under this standard were frequent, particularly during World War I, when speech that might hinder the war effort was deemed a crime. After the case of Schenck versus United States, the clear and present danger standard replaced the bad tendency standard. In this case, Charles Schenck was found guilty of violating the Espionage Act of 1917 by passing out pamphlets urging draftees to resist the draft by peaceful, non-criminal means, such as petitioning for its repeal. Schenck lost. The court ruled that his actions presented a clear and present danger to the military. The clear and present danger standard meant that the government had to prove that speech would result in actions that would hinder war efforts. This standard makes a distinction between peacetime and wartime. In this photo, we see a passenger at an airport being searched. In the post-9/11 world, are some efforts to expand security worth sacrificing a degree of liberty? Many Americans believe so. In the late 1960s, courts began to use the gravity of danger standard. If speech would result in something evil, like the overthrow of the government, the speech was not protected. Dennis versus United States was the case that introduced this new standard for unprotected speech. Several Communist Party leaders were arrested for advocating the overthrow of the government by force. The court ruled that, although the probability of success was low, the gravity or evil of their proposal was high enough that government could limit this speech. This standard was used to prosecute communists during the Cold War. Senator Joseph McCarthy led investigations against citizens, accusing them of being members of the Communist Party. Some states passed restrictions or penalties on communist political activity. The federal courts frequently upheld these policies, concluding that the evil of communism was so great that it could be controlled even if its political success was highly unlikely. In the 1960s, the court abandoned the gravity of danger standard in favor of the preferred position standard. The court felt that freedoms of speech, press, and religion were so important that they should be abridged only with great reluctance. In Brandenburg, the court struck down an Ohio statute that made speech advocating crime, sabotage, and violence illegal. The court ruled unanimously unless the speech was extremely likely to produce immediate lawless behavior, it could not be restricted. The burden of proof was now switched to the government from the individual. This is the standard still in place today. The Supreme Court has determined that some categories of speech do not merit constitutional protection. These include fighting words or inflammatory words that create immediate threat to public safety, defamation, commercial speech, student speech by minors, and obscenity. Defamation means making a false statement that is heard or read by a third party and harms the target's reputation. When the defamation is spoken, it's called slander. When it's written, it's called libel. Commercial speech has gained growing protection, but the government can regulate commercial speech to be sure it is accurate and not misleading, although it rarely chooses to do so due to the powerful lobbying of corporations. Minors have generally not been accorded the same speech rights as adults, although this is not to say they enjoy no constitutional rights. This has been a complex area of law for the court to navigate. Obscenity has never been considered protected speech, but what constitutes obscene material has changed. Recent jurisprudence has been focused on restricting the access of minors to pornography in the internet age rather than focusing on what consenting adults can view or read. The Constitution's religious freedom guarantee is twofold. Individuals are to be free to exercise their religion, and government is not to establish religion. Since 1990, the court has used a neutrality standard, which is less likely to provide legal exemptions for religious practice as long as the law is conceived and implemented neutrally. In the case of Lemon versus Kurtzman, this involved public assistance to schools, including private and parochial schools. Parochial meaning schools that are attached to a certain religion. To determine whether the government could provide aid, it had to meet 3 tests. The aid must have a secular purpose or non-religious purpose. It should advance or inhibit religion, and it must not foster excessive government entanglement with religion. Although the court still uses this standard, it has relaxed this standard in recent rulings, such as by permitting school vouchers, which could be used for religious schools. With regard to school prayer, the court has ruled that public school prayers or similar activities, such as Bible readings, constitute establishment of religion if they imply the endorsement of the school, but students can pray privately while in school. The court has generally ruled against religious displays on public property, making some exceptions for historical monuments. The First Amendment prohibits the establishment of religion, but it also guarantees the free exercise of religion. Are restrictions on free exercise ever permissible? If so, when and why? Let's consider a precedent-setting example. The Sherbert case involved a woman who refused to work on Saturdays because of her religion. This refusal made it difficult for her to find work, and when her state denied her unemployment benefits, she sued. The court developed a test for the constitutionality of a law that affects the free exercise of religion. First, does the law impose an undue burden on religious exercise? Second, was a compelling government interest served by the law? In the case of Sherbert, the court ruled that the law did make it difficult for Sherbert to practice her religion, and that there was no reason for the state to justify that burden. So she did, in fact, receive unemployment benefits. The court now uses a neutrality test instead of the two-part balancing test they used for Sherbert. If a law is neutral and applied neutrally, it can validly limit religious expression. In Employment Division versus Smith, Smith was denied unemployment benefits when he was fired for his job for smoking marijuana. When he claimed this was part of his religious practice, the Supreme Court upheld the state's refusal to provide unemployment benefits. The law prohibiting marijuana validly regulated something that government is already allowed to regulate, and the law was applied equally across all groups. In this case, a woman by the name of Sultana Freeman was required to remove a veil from her driver's license for her driver's license photo. Was this a constitutional right, or was this an impingement on her religious freedom, or was it just a standard law that the government applied to everyone regardless of religion? It was, in fact, deemed to be a neutral law. It applied to everyone no matter what their religion, so she was required to remove the veil. Religious groups strongly protested the neutrality test. In response, Congress passed the Religious Freedom Restoration Act of 1993. This law tried to replace the neutrality test with the balancing standard again. It followed up the next year with a law allowing Native American religious use of marijuana. In City of Bourne versus Flores, an archbishop was denied a building permit to expand a church in a historic district. Citing RFRA, he sued, saying not being able to expand the church placed a burden on the free exercise of religion of his congregation and that there was no compelling state interest. The Supreme Court ruled that RFRA was too invasive on state governments, but has required federal agencies to abide by it. The Supreme Court in the 1960s added significant safeguards to protect the rights of the accused when evidence is gathered, during investigations and trials, and at the time of sentencing, well-known features of the legal system, such as the Miranda warning and the obligation of government to provide counsel, were introduced during this era. Since the 1980s, the Supreme Court has given police more leeway in their investigations. Rights extend to the phases of investigation and arrest, trial, and sentencing. The Fourth Amendment of the Bill of Rights protects citizens from unreasonable search and seizures. Police must have warrants to search homes, and to obtain the warrants, they must have probable cause. That is, they must have enough information to suggest that a crime has taken place and that an individual or location is linked to the crime. But what is reasonable? Pretty much anything, according to recent court rulings that have allowed strip searches for arrests for minor offenses and stopping drivers without suspicion of wrongdoing. Before entering property to conduct a search, police officers need to obtain a warrant that specifies the items or information sought in the search. Evidence seized in the absence of a judge's warrant may be deemed inadmissible in court. But what if the court does obtain evidence illegally? As long as they have it in hand, can they use it? In Weeks versus the United States, the courts prohibited federal courts from basing decisions on evidence obtained improperly, a principle known as the exclusionary rule. Evidence that is gathered during an illegal search cannot be introduced in a trial, no matter how critical it may be for conviction. In Mapp versus Ohio, the Supreme Court applied the rule to the states. Over time, the court has become more flexible in its enforcement of the exclusionary rule. The general principle stands, but the court has allowed for introduction of questionably obtained evidence in specific circumstances, such as if the police exercised good faith to collect the evidence properly or could have collected it properly. Can you recite the Miranda warning? Is this something that you're familiar with because of watching TV, police dramas, or movies? The Miranda warning is based on the court's 1966 decision in the case of Miranda versus Arizona. It emerged from the Fifth Amendment's guarantee against self-incrimination. In subsequent rulings, the court has made the burden on the police less restrictive. One of the rights guaranteed by the Constitution and mentioned in the Miranda warning is the right to have the advice of legal counsel during questioning and trial. The court has ruled that the government must provide counsel if a defendant cannot afford to pay for it. In Gideon versus Wainwright, the court ruled that defendants in all felony cases must be provided with legal assistance if they cannot afford their own. Most of the court's rulings concerning the Eighth Amendment protection against cruel and unusual punishment have concerned the application of the death penalty. The court has maintained that the death penalty itself is not unconstitutional, but has placed restrictions on its use, especially in regard to minors and the mentally disabled. This chamber at San Quentin Prison in California was used for execution by lethal injection through 2007, when it was replaced by a new facility. In 2008, the Supreme Court lifted the restriction it had placed on lethal injection executions. The court determined that this method of execution did not constitute cruel and unusual punishment and was constitutional. The lines, "I plead the Fifth," or "I refuse to answer on the grounds that I may incriminate myself," are standard in movies or TV shows. The Fifth Amendment, however, is not just a punchline. It gives citizens the right to due process and protection against self-incrimination and forced confessions. The discovery of new rights that are protected by the Constitution has come about in two ways, through the Ninth Amendment and through the 14th Amendment. One or the other of these means has established many significant new rights. The most far-reaching of these rights in terms of its social impact has been the right to privacy, which is the basis most notably for the dramatic changes in government regulation of birth control, abortion, and sexual behavior. In the 1960s, both the federal government and the states criminalized the use of contraceptives. In 1965, the case Griswold versus Connecticut successfully challenged these laws when the court declared that there was a constitutional right to privacy for married couples. The Constitution does not use the word privacy, but there are enough provisions in the Bill of Rights to suggest it. In 1973, the court used the Griswold precedent to extend the right to privacy to cover a woman's right to seek an abortion. Although the court has maintained the basic right established in Roe, it has allowed states to impose significant restrictions on abortion. The Supreme Court has declared that abortion is a protected constitutional right, meaning that states cannot prohibit it. But because access to abortion is not considered a fundamental right, the significant variation in law and policy across the states is permissible, as long as states do not create an undue burden on access to abortion. Most states require women to obtain counseling before having an abortion, with various requirements regarding what the counseling must cover. Counseling is usually coupled with a waiting period of 24 hours prior to the performance of the abortion. The Supreme Court's 2004 decision in Lawrence versus Texas was not based on privacy considerations relating to homosexual activity, but rather on the guarantee of liberty in the 14th Amendment. Congress has passed legislation to protect privacy rights, such as how businesses collect and sue financial information. Students have a right to privacy concerning their educational records, and the right to privacy is contentious because it refers to interpretations of the Constitution rather than to any concrete references to privacy in the document. Overall, ask yourself this question as we close out this lecture. Have the court's rulings on civil liberties strengthened citizens' rights or weakened them in favor of government restrictions?